breakout room?
Yes, Your Honor. Let me, it'll take a minute. He's out in the hallway.
All right, thank you. So Detective Edwards, I'm going to send you to breakout room number 1. Diaz, number 2. Flores, number 3. Who else on the screen is your witness, Mr. Garcia?
Genesis?
Genesis Cirilo.
Yes,
I'm going to send you to breakout room number 4. All right, who else?
that should be it.
Okay.
And I believe defense has 1 witness.
Yes, Judge, I was double checking to make sure she was in the room. Judge, I have Felicia Guerra Villarreal.
Yes, she's on the screen. Do you need to speak with her?
If I can be put in a breakout room briefly with her, but I just didn't know if you were gonna need to put her in her own breakout room as well.
Yes, I'll put you and her in breakout room number 5. And if you
Okay.
can come back, and since the rule is going to be invoked, if you can just let her remain there.
Got it, Judge.
All right. So Zenon Benitez Jr., Carlos Martinez, are you ready? What's the prosecutors on this?
I am.
All right, the court is calling 2020 CR 7273, State of Texas versus Zenon Benitez Jr. If I could have parties announced for the record, please, for the state,
Alexandra Williamson.
for the defense.
Carlos Martinez, Your Honor, for the defendant.
All right, and Mr. Benitez, are you Mr. Zenon Benitez Jr.?
Yes, ma'am.
All right, Mr. Benitez, I'm going to show you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
And we're proceeding by video today because of the pandemic. However, the defendant is present in the courtroom. Is there any objection from the state or the defense that we proceed by video? State?
No, Your Honor.
Defense?
None, Your Honor.
The court will find that defendant has knowingly and voluntarily consented to appear by video. Next, Mr. Benitez, I'm going to show you what's entitled Motion to Revoke Community Supervision and First Amended Motion to Revoke Community Supervision. Did you review those documents with your attorney? Did you understand them? And did you did you understand them?
Yes, ma'am.
Are you the same Zenon Benitez Jr. who's placed on community supervision in 2020 CR 7273 for the offense of burglary of a building with intent to commit theft on September 23rd, 2020 for a period of 2 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. From the state's first amended motion to revoke probation, the defendant violated condition number 1 on or about the 24th day of February 2021. In Bexar, Texas, the defendant, Zenon Benitez Jr., committed the offense of evading arrest or detention with vehicle in violation of condition number 1.
How do you plead to that, true or not true?
True.
The state will waive all remaining allegations.
Any objections to the state's waivers?
None, Your Honor.
Mr. Benitez, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility and up to a $500 fine? Did you understand?
Yes, ma'am.
Mr. Benitez, you need to pull that mask above your nose, otherwise it doesn't work.
Okay, I'm sorry.
That's okay. Understanding that, do you still wish to plead true to violation of condition number 1?
Yes.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Your Honor. We're asking for you to find the motion true, grant the motion, reform the defendant's underlying judgment to 6 months and sentence him to 6 months in the state jail facility. We will TIC 9 mag 603861.
Correct.
Is that the agreement, defense?
That's correct, Your Honor. That's the agreement that we have, Your Honor.
Mr. Benitez, are you requesting that the court follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes.
Then this is what the court will do. The court will grant the motion. The court will sentence you to 6 months in the state jail facility. Take in consideration night mag number 603561. Give you credit for any time served. There's a $500 fine. Time and money will run concurrent.
Your Honor, the night mag is 603861.
I'm sorry. Take in consideration 603861. Is there anything else from either side with regards to sentencing?
No, Your Honor.
Defense? Anything else?
I was to see, I don't know.
No, just 1 second.
Sorry.
Mr. Martinez, anything else?
Yes, on behalf of my client wanted to see if you could give him a few days to get his affairs in order, Judge.
Okay, no. All right. Mr. Benitez, I'm showing you a document entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes.
All right, because you entered a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
And again, we can go off the record. Mr. Benitez, that mask is doing you zero good
Good.
if your nose is not covered. And when your nose is not covered, it's doing the people around you zero good. You might as well not be wearing one. Okay?
Yes.
All right. And Mr. Benitez, part of the reason why you can't turn yourself in later is because while you were on probation, you picked up a new offense. Do you understand?
Yes, ma'am.
And that's the number one thing you should not do while you're on probation.
Okay.
All right. Good luck to you, Mr. Benitez.
I'm sorry. I have a question. Like I said, because I have two kids, that's why I do need just a 1 day. Or I can have I can put a monitor on for 2 days or.
No, Mr. Benitez, but good luck to you.
Hold my phone. I'll get enough.
All right, Mr. Martinez, you're excused.
Thank you, Judge.
Who are the prosecutors on Raymond Martinez and Victoria Cruz's client?
I think it's Jordan, Judge.
That's correct, Judge.
Mr. Cavazos, I need you to unmute. And I need you to find a stationary place.
You're still muted, Mr. Cavazos.
Court is calling 2019 CR 10398, State of Texas versus Robert Lee Cavazos. Could I have parties announced for the record, please, for the state,
Jordan Brown for the state.
for the defense?
Raymond Martinez.
All right, and are you Mr. Cavazos? You need to unmute.
Yes, ma'am. I'm sorry.
That's okay. We're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
No, Your Honor.
Mr. Cavazos, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you what's entitled what is entitled Acknowledgement of Discovery. Counsel, have you received all the discovery in this case, and did you review that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Cavazos, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? And did you understand it?
Yes, ma'am.
Counsel, do
Yes,
you
ma'am.
waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge. We are waiving one of the two enhancement paragraphs. The second one, we are proceeding on the first, the 2014 offense cause number.
Any objections?
No, Your Honor.
Mr. Cavazos, I'm going to show you a document entitled Court's Admonishment and Defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with is evading arrest, detention with a vehicle? That's normally a third-degree felony, but because of the enhancement, that's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement? If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He was, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Cavazos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain page, defendant is to agree that he's been previously convicted of one or more felonies for enhancement. Punishment is to be assessed at 5 years in the prison. There are no applications. State will take in consideration JN numbers 1963584 and 1984951. Cause numbers 2020 CR 5274, 2020 CR 6577, County Court cause number 637319, cause number 2020 CR 7911. And if the defendant fails to appear for punishment, he is subject to the full range of punishment. Mr. Cavazos, did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defenses, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as alleged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the plea?
State offers States Exhibit 1 and attachments.
Any objections?
No, Your Honor.
Mr. Cavazos, I'm showing you a document entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call on the right to remain silent? I think your client is frozen.
There he is.
Okay, I'm back.
All right. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call on the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. Mr. Cavazos, I'm gonna read to you the enhancement paragraph. I need to know how you plead to it, true or not true. It says, and it is further presented in and to said court that before the commission of the offense alleged above, hereinafter styled the primary offense on the 19th of May 80, 2014, in cause number 2014 CR 3963W in Bexar County, Texas, the defendant was convicted of the felony of felon in possession of a firearm. How do you plead to that, true or not true?
Not true. True. This is yes, ma'am. True.
Are you sure?
Yes, ma'am. It was felon in possession of a firearm.
Yes.
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. The court will also find in the enhancement paragraph 1, in the indictment true, based upon your plea of true, and based upon states exhibits 1 and attachments. Are we proceeding with sentencing?
Judge, since there's no application and he's not in custody, we're asking V to set a date. He can turn himself in at the courthouse. He just needs to clear out his apartment and get into custody.
All right, Mr.
Ms. Boyd,
Cavazos.
Yes, ma'am. The only thing is because I don't have any family in San Antonio really, so my aunt, she works at in Rosenberg. She runs a funeral home, and that'd be as soon as she could come by would be not this weekend, next weekend, just so she was gonna rent me the U-Haul. I was gonna load everything up in there, and she was gonna take it to Rosenberg with her. That way she can put it in the storage. And then I also have a 5-year-old lab that I just want to make sure that she gets situated. You know what I mean? I just want to make, you know what I mean? I've had her for 5 years, so she's closer than my own son. You know what I mean? But I just want to make sure she's okay, and the apartment gets everything situated with the apartment.
All right, Norma. Are you able to recall this from March 31st?
Yes, ma'am.
All right, Mr. Cavazos, you're going to be back here on March 31st for sentencing.
Okay.
You need to come to the 187th District Court. That is
ma'am.
on the 4th floor. It's 300 De La Rosa, and I'm sure Ray has informed me that he calls all his clients before their court dates. So I'm sure Ray will call you and let you know where you need to be
Okay.
in case
Thank
you
you, ma'am.
forget. You're welcome.
No, I won't forget. I won't forget. Thank you for the time.
All right, thank you. With that, we'll close the hearing. All right, and state, my understanding is on Mr. Austin Young, you all have an agreement. Who is Alex? Oh. Alexandra. All right, thank you. Alexandra Williamson?
Yes, Judge, sorry.
That's okay. I received this document from defense attorney saying that you all have agreed to a bond on Mr. Austin Young.
Oh, yes.
Okay. Okay, and is that agreement the 5,000?
Yes, ma'am.
Moment. Robert? I've signed the documents for Austin Young. All right, thank you. All right, are all the parties ready on Cameron Scott?
Yes, Judge.
Yes, Judge.
All right, courtroom. Could I have Mr. Cameron Scott, please?
Yes, Judge.
Thank you.
Let's go. Here you go.
All right, the court is calling 2017 CR 7952, State of Texas versus Cameron Scott. Could I have parties announced for the record, please, for the state,
Joe Ray Garcia for the state.
for the defense?
Paula Bettis for Mr. Cameron Scott.
All right, we're proceeding by video. Because of the pandemic, however, it should be noted for the record that the defendant is in the courtroom. Is there any objections to this hearing taking place by video, state?
No, Your Honor.
Defense?
No, Your Honor.
Mr. Scott, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
The court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm going to show you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and states motion to supplement pending motion to enter adjudication of guilt and revoke probation. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Cameron Keith Scott who was placed on deferred adjudication in 2017 CR 7952 for the offense of assault family household member with a previous conviction on November 27, 2017 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Judge, before we begin, I have a few preliminary matters to discuss.
All right, just one moment.
Okay.
What are the preliminary matters?
Yes, I discussed with defense that there is a clerical error on the motion to enter adjudication of guilt. That error was where it states violation of condition number
Yes, please.
15. It should state violated condition number 17.
All right. Defense, any objection to the oral change?
No, Your Honor, as long as it's just the number itself, not the substance of the allegation.
All right, is that correct?
Yes, Judge, it's just changing where it says 18 in both spots to 17.
All right, you say where it says, okay, thank you. Oh, could you stamp that for me? Yes, thank you. All right, then that'll be noted for record that violation of condition number 18 should say violation of condition number 17 in both places. Is there anything else before we start?
Yes, Judge, and we'd like the court to take judicial notice of the court files and its documents.
Defense?
I didn't hear the last part, Judge, I'm sorry.
They're asking that the court take judicial notice of the court's file and the court's documents in the court's file.
No objection, Judge.
So noted.
May I proceed?
Yes.
Now comes the criminal district attorney of Bexar County, Texas, and would show the court that the defendant in the above styled and numbered case was placed on probation under Article 42A.101 Texas Code of Criminal Procedure for the offense of assault family household member with previous conviction, and was placed on probation by the court on the 27th day of November 2017 for a period of 5 years under the provisions of adult probation and parole law, as reflected by the filing of the court that evidence substantiated the defendant's guilt in this cause, that thereafter, during the term of said probation, defendant violated the terms and conditions therein in the following particulars, to wit, violated condition number 1, on or about the 23rd day of November 2020 in Bexar County, Texas, the defendant, Cameron Keith Scott, committed the offense of assault in violation of condition number 1.
How do you plead to that, true or not true?
Not true.
State?
Violated condition number 17, on or about the 23rd day of November 2020 in Bexar County, Texas, the defendant, Cameron Keith Scott, did then and there find himself inadvertently in contact with Felicia Gara and threatened, assaulted, or verbally abused said person in violation of condition number 17.
How do you plead to that, true or not true?
Not true. Not true.
State?
And on the state's motion to supplement pending motion to enter adjudication of guilt and revoke probation, defendant violated condition number 1 on or about the 23rd day of November 2020 in Bexar County, Texas. The defendant, Cameron Keith Scott, committed the offense of resisting arrest in violation of condition number 1.
How do you plead to that, true or not true?
Not true.
All right, state, you may call your witness, your first witness.
The state calls Genesis Cirilo. Your Honor, may I go in the breakout room to retrieve her?
Any objections to the state bringing the witness into the main room defense?
No, Your Honor. No.
Yes. And she's in breakout room number 4. All right, Ms. Cirilo, could you raise your right hand for me and please unmute yourself?
Can you see me on here? Oh, okay.
Yes.
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. If you could state your name for the record and please spell it.
Genesis Cirilo, Genesis, last name Cirilo.
All right, state.
Cirilo, you just introduced yourself. Can you tell the court what you do for a living?
Yes, sir. I am an adult supervision officer with Central 2 unit over here at 207 North Kamal, Maine.
And is that for Bexar County?
Yes, sir.
And how long have you been a probation officer for?
A little over 5 years now.
And while you were a probation officer, are you supervising an individual by the name of Cameron Keith Scott?
Yes.
And is he on this Zoom screen today?
Yes, yes.
And can you please identify him by an article of clothing?
He is wearing a black shirt, gold chain.
And for the record, the witness has identified the defendant. Ms. Cirilo, when were you first placed, or when were you initially placed on as Mr. Scott's probation officer?
I took over this case on 10/9/19.
And do you know when he was first placed on probation?
He was first granted on November 27th, 2017.
And what was the term for?
Let me see. For 5 years, I believe he's on for 5 years.
And Mr. Cirilo, let me ask you, do you have reports made for Mr. Scott?
Yes.
Okay, and would it help you refresh your memory if you looked at those reports?
Yes.
And let me ask you one more time, when were you initially placed on as his probation officer?
10/9/19.
And when you were placed as his probation officer, did you go over all the conditions that he was to abide by while he's on probation?
Yes, every office visit, we would speak about conditions.
And to your,
Make sure,
I'm
I'm
sorry,
sorry. Just speaking about conditions, making sure he's maintaining no harmful or injurious contact with the victim on file, Felicia Villarreal, and discussing what he has done so far in his case as far as pro-social behavior.
And to your knowledge, did he understand those conditions?
From what we would discuss, yes.
And also to your knowledge, was he aware what was expected of him while he was on probation?
Yes, sir.
Did he have any concerns about being able to abide by those conditions?
No, sir.
Ms. Cirilo, did you go over the terms and conditions of community supervision that was ordered by the court to Mr. Scott?
Yes, sir. Every office visit, we discuss his conditions as his progress, what he's done so far, what he needs to do, every office visit as documented.
And as a probation officer, are you a custodian of records?
Yes.
And do you keep these records, or are these records kept in the regular course of business?
Yes.
Your Honor, may I share the screen with the witness?
Yes.
Judge, can I take a look at what
To see what's being
the
shared.
state- correct.
Yes. All right, this is what we'll do then. So that the defense can review it before the court sees it. Is that what you're asking for, Ms. Pettis?
Yes, Judge. Yes, I want to make sure that I have a chance to review it. That
All
I
right.
that I have objections at that point.
All right. Mr. Garcia, if you go to breakout room number 4, please.
Yes, Judge.
And Ms. Pettis, if you go to breakout room number 4, and you both
Okay.
can review what documents he wants to submit. And
Okay.
while you're there, if there are more documents that he wishes to submit, if you all could review them.
Yes, thanks, Judge.
All right. Did you receive it to go to 4? Mr. Scott, if you would like to have a seat while they're conferring in the other breakout room, you may do that.
Well, thank you, ma'am.
You're welcome.
We're back, Judge.
All right. To the courtroom, they are back. All right, we're back on the record. And what were you seeking to enter, Mr. Garcia?
Your Honor, I was seeking to enter State's Exhibit 1. I wanted to share screen with the witness.
All right. And share screen is on.
Okay, thank you. May I proceed?
Yes.
Mr. Cirilo, I'm showing you what has been digitally marked as State's Exhibit 1.
Yes.
Do you recognize this exhibit?
Yes.
And how do you recognize it?
These are his initial conditions of probation that have been signed with the court.
And let me scroll down to the bottom. To your knowledge, has this been altered in any way?
Yes, so originally he was a no contact order, and then that was changed to a no harmful or injurious contact order.
Okay, I understand that, but I mean the exhibit, the document itself.
What was your question? I'm sorry.
Has the document been changed or tampered
Altered?
with in any
No.
way? No.
No.
Your Honor, at this time, the state moves to enter State's Exhibit 1.
Any objection?
No objections, Judge.
All right, State's Exhibit number 1 is admitted.
Mr. Cirilo, now I'm showing you what has been pre-digitally marked as State's Exhibit 2. Do you recognize this exhibit?
Yes.
And how do you recognize it?
It has his name up on the left corner, Cameron Scott, and he has a no contact order with the Felicia Villarreal and to report weekly in person for a period of 2 months. And these are the amended conditions.
And as his probation officer, did you go over both of these documents?
Yes, he is aware that there should be no harmful or injurious contact or no contact with Miss Felicia Villarreal.
And has this document been tampered with or altered in any way?
No.
The state offers State's Exhibit 2 into evidence.
Any objection?
Judge, now this one I will object to for the mere fact that I believe that there are some missing documents. There might be 1 or 2 others, and correct me if I'm wrong, but that amended the condition. So at some point it went from no contact to no harmful or injurious and back and forth. And so I just want to make sure that the court has a full understanding of when things changed, and if this was the only change, then so be it. But if there are additional ones, then we should know about those, or modifications, I should say, when removing the no harmful or injurious contact to no contact and back and forth.
Your legal objection.
Oh, my legal objection is I'm objecting to it on the fact that it's incomplete and there may be missing pages to that.
All right, that will be overruled.
Going to exit the share screen.
State's Exhibit number 2 is admitted.
Mr. Cirilo, I'm going to ask you about the defendant's time while on probation. Are you aware of any motions to revoke regarding Cameron Scott?
I'm sorry, you cut it. You cut out.
I'm sorry, I asked, are you aware of any motions to revoke that have been filed against the defendant?
Yes.
And then, to your knowledge, how many motions to revoke have been done?
Well, let's see here. You want the full history on here? He had a VR-MTR on 11/25/19. Modifications were done on that date. Actually, after that, he had a amended MTR 7/16/20.
Judge, if I can stop.
Just
and
one moment. All right, everyone, time out. So I'm going to need several things for everybody to remember. Number one, court reporter needs everybody to speak up. So what has been happening is, and I notice this a lot, people will start speaking at the level that I'm speaking at, then all of a sudden their voice level dips to down here and the court reporter can't hear. So everyone needs to keep their voice raised to the level that I have it at or higher. The second thing is we can't talk over each other. The third thing, and this is what I'm going to do to handle objections, because I understand that sometimes people on the screen can't see other participants. I'm able to see everybody, but when you're concentrating on your testimony, you're not looking at the boxes. So what I'm going to start doing when an objection is raised, I'm going to mute the person who's speaking so that I can hear the objection. So, Ms. Pettis, you were interrupting. Did you have an objection?
Yes, Your Honor. I object to the officer reading from a report that has not been admitted into evidence at this point in time, from what I understand.
All right, State, lay the proper foundation for your witness, please.
Yes, Judge, I will. Mr. Cirilo, as his probation officer, do you make reports based on your supervision for the defendant?
Yes.
And would it help you refresh your memory on questions I asked to look at that report?
Yes.
And I asked, if you do look at that report, please don't read off of it. You can look at it and then look up at the screen and give your answer.
Right.
May I continue, Judge?
Yes.
Now, let's just start chronological order. When was the defendant's pre-motion to revoke enter, his first one?
His first motion to revoke, that was on 11/25/19.
Okay, and do you know what happened with that motion?
Let me see. I would have to review that in my NCSS.
All right, and then I'm sorry to interrupt, Ms. Cirilo, for some reason we're losing your face. All right.
Can you see me better? I'm sorry, I'm in office right now. It's kind of hard because my speaker's under my desk.
Okay. All right, State, you may continue.
Did you state you needed to review that from the report?
Yes, yes.
Okay. You can take the time to do that, and then when your memory is refreshed, go ahead and look up at me.
Okay. Okay, I'm ready.
Okay, my question was, what happened to his first motion to revoke?
Okay, so the amended, it was modified after that, after he had went to court. That some amended conditions were completed on 1/17/20. Modification was for the no contact order.
Okay, and when was that? The date?
On 1/17/20.
And were you his probation officer yet?
I took over his case 10/9/19. So yes.
And after that, did you file another pre-motion to revoke?
Yes.
And what conditions did you allege that he violated while he was on probation?
Sorry, that one was for 7/16/20. That one was for condition number 17. That was the contact or attempt contact with the Miss Felicia Villarreal. January 28th, 2020.
And was he continued on probation?
Yes.
That motion to revoke?
Yes.
And again, after that, did you file any other violation reports?
Yes, there was an amended motion to revoke for July 8th, 2020, and that was for the violation bond protective order.
And was he continued on probation? Was that motion dismissed?
Yes.
Okay. Now just going chronologically after that, did you file another motion to revoke?
Yes.
And what were those conditions for?
That was for the assault for November 23rd, 2020. And then the condition number 18, which was a no harmful injurious contact condition.
Okay, let's backtrack a little bit. You said for violating the condition of assault, is that condition number 1?
Yes, condition number 1.
And what is that condition?
The violation of condition number 1 was a new offense that was for November 23rd, 2020.
And what was the second condition?
The second was condition number 18, and that was also for the no harmful injurious contact order.
Okay, and let me make you aware there was an oral motion to amend that to condition number 17. Would condition number 17, looking at the order to modify, is that correct?
Condition number 17.
Yes.
Let me see. Modifications. The last, are you talking about for the no harmful injurious contact order?
Yes.
That is condition number 18. That was a modification that was done for condition number 18.
Okay. Permission to show screen, Your Honor.
Granted.
Mr. I think we're on the same page here, but it was just a clerical error. I'm showing you what has already been entered into evidence as State Exhibit 2, which you recognized. What is condition number 17?
Condition number 17 is a no contact order.
Okay, and was this on the amended motion for community supervision?
Yes.
Now let me ask you, you just discussed the numbers that are the violation numbers that you filed. Why did you file those?
I filed the most recent MTR is what we're discussing. The most recent MTR, I filed condition number 1 due to the new offense, and condition number 18 because of the recent modification that was done on 7/16/20 for the no harmful injurious contact order. Those are the 2 that I filed on. And then he had a recent another number one that was for November 23rd. That one I was advised to of that new offense, which was the resisting arrest new offense.
And you say most recent, is that the reason we're here today?
We're here for the motion to revoke, yes.
And were all of these violations arising out of the same incident, to your knowledge?
Yes.
And did you receive a police report on this?
I actually did not receive an offense report on the newest one.
Okay. And all this time being his probation officer, what would your recommendation be to the court?
My recommendation is revocation on file. That's what I'm requesting over here for probation.
And why are you requesting that?
Due to the continuous harmful injurious contact with the victim on file, I feel at this point it is a concern. I mean, due to the MTRs, various MTRs that we've had to file already continuously.
And has there been in your opinion, has there been a continuous problem with the complainant?
Yes, as far as the VR MTRs with the harmful injurious contact order or the no contact, yes.
No further questions, Your Honor.
Defense,
Officer Cirilo, so let's start off with what is the difference between, if you can explain to us briefly, between a no harmful or injurious contact order and a no contact order?
No contact, he is to have no contact whatsoever with the defendant or her family through phone, face-to-face, inadvertently, any location. I mean, if he's around her in any other location, that would be the no contact order. The no harmful or injurious contact order, he can have contact with her. However, no harmful or injurious obviously means he cannot, physically harm her. If problems are arising as far as any physical abuse, emotional abuse, verbal abuse, that is what no harmful or injurious contact order means.
Okay, and on November 27th, November 23rd, 2020, what were the conditions as far as no contact or no harmful or injurious contact? What were the conditions that were in place?
His original conditions, I'm sorry, you said November?
No. His conditions that were in place at the time of November 23rd, 2020.
November 23rd, 2020. November 23rd, 2020.
Yeah.
Mr. Scott had the no harmful or injurious contact order, which is condition number 18.
Okay. And so if he inadvertently makes contact, that doesn't apply, like you said, right? That inadvertently is only for no contact, correct?
Correct.
Okay. And to your knowledge, on that date, when you filed that violation report and submitted it to the court, what was your basis of filing that Mr. Scott violated condition number 17?
It was for the most recent one. It was condition number 18 for the no harmful or injurious contact order.
Correct.
all right, I'm sorry, time out. Let's be clear for the record. The state asked for an oral correction to violation of condition 18. So condition number 18 in the motion is now condition 17. Or are we talking about some completely different motion?
So this modification was done after he had first had a no contact order, and then the modification was done for the no harmful or injurious contact order. That
I don't think he's,
no, that's not what I'm asking. Okay, this is what I'm asking. I have the motion to revoke here, and that's what we're having the hearing on.
Mhm.
So the state asks that this be changed orally from a violation of condition number 18 to violation of condition number 17. The way the violation of condition number 18 is written, that remains. The only thing that's being changed is the number. So my understanding from both the state and the defense that they're in agreement to change the number to number 17 instead of 18. I just want the record to be clear. So are we talking about a different number here, or are we talking about what's supposed to be 17?
Judge, my question, if I can clarify, my question to Officer Cirilo was in reference to what has now been amended to reflect the correct number as condition number 17. And so Officer Cirilo, when I make reference, and I don't know if we need are we on the record again, Judge, or are we off the record?
No, we never left the record.
Okay,
We're still on the record, yes.
I couldn't remember. Okay, Officer Cirilo, so when I make reference to condition number 17, I'm referring to the correct number. Although on the paper that's probably in front of you or in front of all of us, it said violated condition number 18. We have now agreed to change it to 17, and so that's what I'm referring to, number 17. So when I ask you violated condition number 17 on the 23rd of November, 2020, when you and not looking at this motion, but when you yourself filed the violation report, what was your basis for that?
Due to the new number 1, we also alleged the condition of which the no contact order is on.
Okay, so you based it upon the new number 1, and the new number 1 is what?
The assault, the November 23rd, 2020 assault.
That's the new charge, or?
Yes, the new offense. When I alleged the new number 1, that was for the, we also alleged the condition of the no contact.
Okay, so, and maybe I'm not making myself clear enough, Officer Cirilo. What I'm referring to is when you make a report as an officer and you submit it to the court, you have to have a reason why you're alleging my client or any other defendant has violated the conditions of his probation. So you allege condition number 17. I'm saying, how did he violate condition number 17? In your opinion, and why you submitted the violation report, how did he do that?
I allege that because of the condition of the new assault charge, because of the new number 1 that he had picked up. He is to have no contact or no harmful or injurious contact with the Miss Felicia Guerra.
So I'm confused. The new number 1, when you say new number 1, are you referring to a condition or are you referring to a new offense?
The new offense, the condition. When I say the new number 1, we call it the new number 1 over here for condition number 1, meaning condition number 1, which would be the new offense.
Okay. And so is that what he was charged with and arrested for though?
He was arrested for that. I mean, I'm not.
You're not what?
I'm not too sure exactly what you're asking me. I mean, he was arrested for the assault. So we go ahead and we complete paperwork on our end for the new number 1, as well as the contact.
Okay, so in your
condition.
Okay, so Officer Cirilo, on your records, you have that Mr. Scott was arrested for a new offense of assault.
That is, he was arrested on that date, which is why I completed this MTR.
Okay. Not any other offense, but an assault, correct? Is what you're saying?
From what I first completed was the assault.
Okay. And so let's backtrack a little bit. When you first, how do you, as an officer, how do you become aware of one of your probationers or probation clients picking up a new offense or violating a condition, but in this particular instance, picking up a new offense? How is it made, how are you informed about that?
We're able to look in CSS in our system here when we have new arrests, as well as our MOCA screen, which will tell us the offense date and the information due to that new offense.
Okay, and so when you looked into your CSS, what was the new offense?
I mean, I would put assault on there due to the offense. So whatever was in MOCA at that time is what I placed in.
Okay, and so whatever's in MOCA, you put exactly as it is on the new, I guess, on the condition that you're alleging in number 1, correct?
Yes.
Okay, so at the time, what you're stating here for the court is that the offense was listed as assault.
Yes.
Okay. Now, to your knowledge, did that ever change?
Not to my knowledge.
Okay. Now, when you're informed about the assault, or I should say not assault, but the alleged offense, is any other information given to you?
No.
Okay, so you don't know the facts of the case, correct?
No.
You don't know anything other than the offense and the name or the title of the offense, right?
Correct.
Okay. Okay. So do you know what it, and you may not know this, right? Because you, and I don't expect you to know this, but so if you do not, it's fine. But when you allege an assault or an assault is alleged, do you know whether there has to be contact or not, whether there has to be violent contact, whether, you know, anything? Do you know any of those things?
No.
Okay. Yeah. And so when you allege that he violated condition number 1 based upon the offensive assault, you're going based upon only MOCA, right?
Yes, or if we receive an offense report.
Okay, I just want to make sure about that. So now moving on to violated condition number 17, the allegations made there, did you put those into that, or did you send that over to the court?
Yes.
Okay. And so how did you become aware of those particular facts of contact?
I'm sorry, I'm still a little confused with these conditions.
So in condition number, what is formerly labeled as 18, now 17, that on or about the 23rd day of November 2020, Mr. Scott did in there find himself inadvertently in contact with Felicia Guetta. All of that, did you, I know that the state prepares this motion, but
Yes.
Did you provide the state with that information of the facts?
Yes, I placed in condition number 1 and that other condition. Yes.
So number 17 you placed in there as well?
Yes.
Okay, and so at what point did you find out those specific facts of the threats, the assault, the verbally abused?
I mean, once he, like I said, once he was committed for the new offense, or that we had him once he was arrested, that's when I had alleged that condition as well. Again, this is I just because of the new offense, we have to place that in here as well.
Okay, but those are specifics. So how did you get to that point of concluding that it was by threats, assaults, and verbal abuse?
In my professional opinion, it's based on the new offense.
Are there other ways to commit that offense other than the ones that you listed?
Objection, Your Honor. It's speculation outside her expertise.
Judge, she just referred to the fact that it's her professional knowledge.
Either she knows that or she does not know. You can answer the question.
What was the question?
So in your professional knowledge, you stated that that's what you usually tie to the offensive assault, correct?
Yes.
Okay. Now, are there additional what's called means to commit an assault? Meaning, are there more than the ones that are listed?
I would say no.
Okay. Would there be less? Meaning,
I'm
Do
not
you-
too sure.
okay. But you do agree that you were the one who listed those threats, assaults, and verbally abused, right?
Yes.
Okay. And you're the one who listed those, although you only had the knowledge of an alleged assault, correct?
Yes, they're auto-populated into the condition.
Okay.
So yes.
And so when you make the allegations or the statements today here in court that Mr. Scott committed the offense of an assault, you don't really know the background of the case, correct?
No.
Okay. And when you make the allegation that he continues to have harmful and injurious contact, are you stating he's having contact with her even when he has a no contact order? Are you saying he's had no harmful or injurious contact? I'm kind of confused because you went back and forth as to that. So when you say the no harmful or injurious contact, you also don't know what facts surround this case to then allege that, correct?
I'm just gonna say no.
Okay. What was y'all's relationship like? When I say relationship, obviously, as an officer and a probation, person on probation, some, I'm sure in your experience, you get along with some you do not. Was Mr. Scott somebody that you got along with from day one?
Mr. Scott was fine on probation. We did discuss how he was doing it in home. He would discuss his children and that he would take care of them, and when things would get heated, how he would cope with that, because that is part of our conditions here to discuss.
Okay. And let me rephrase this. Did you two have a working relationship in the sense of you got along with Mr. Scott?
I would say we had decent rapport.
Okay. To date, has Mr. Scott completed all of his classes?
Yes, he completed his community service hours most recently.
Okay, to date, has he completed any of the family violence, batterer intervention, any of those type of classes that were ordered by the court? Has he completed those?
Yes.
Okay. What were some of the other conditions? And I don't have it, the state's exhibit number 1, if you can refer back to that and let's see. And your records, to your knowledge, which I'm sure you have it there in front of you, has Mr. Scott completed all of his conditions at this point in time?
He has, yes.
Okay. And how many times was there any time in which it may have been, you may have been unsure, or he may have been unsure as to whether what was in place was a no contact order or a no harmful or injurious contact order?
I believe we had that discussion back in January, when it was most recently changed from no contact to no harmful or injurious contact.
Okay, and that's January of 2020?
I believe so. I would have to look back on here. I believe it was in January.
Okay. And did you ever discuss with Mr. Scott the relationship that he had with his child's mother, Felicia Guetta?
Yes, every office report we did.
And you were aware of the fact that they were still trying to co-parent, correct?
Yes.
Okay, and you were aware of the fact that his mother passed away, Mr. Scott's, correct?
Yes, I believe we discussed that. In
Okay.
the previous report.
Okay, and do you typically discuss, other than those items, things that may be psychologically, affecting probationer?
Yes, we do.
Okay. Now, on the night of the offense, I just want to go, or a night of the November 23rd, 2020. I know that you've already told the court here that you had no knowledge and still have no knowledge of the facts regarding the case, correct?
Yes.
And so I just want to, it's a yes or no answer. When you allege those things that happened in number 17, you didn't allege them based upon specific facts, correct?
Yes.
Objection asked and answered.
That'll be overruled.
Okay. And, but instead you alleged because you said that's just standard procedure of what you're taught.
Yes.
Okay. And in regards to your testimony earlier about being advised to supplement the MTR, who were you advised by?
The supplemental MTR for the resisting arrest.
Yes, you said earlier you testified that you were advised by somebody to amend it, modify it, supplement it. Who advised you?
Not advised, but I was notified of the resisting arrest, which is why I did the supplemental on that. And it was I received information from the court for the offense.
Okay, were you aware that that offense was dismissed?
No, I was not aware of that.
Okay. And when were you notified of the offense?
I would have to look into my information, my emails for that.
All right,
And it was
excuse me, sorry to interrupt, but the witness is saying that she received information from the court about the new offense. I just want the record to be clear. When she says court, that is not the judge. That is not me asking for new alleged violations of conditions to be filed. So I want the record to be clear on that. And I'm sorry, you can continue.
Officer Cirilo, when you say court, who do you receive an email from? Is it a clerk, or is it, when you say court, do you mean the DA's office? Who are you referring to?
It could be the CLO, or it could be attorney, or it could be anyone. Excuse me, I'm sorry, I'm in office and I'm receiving phone calls. It would be a member of the court, as far as a CLO, or more than likely, I believe it was actually the CLO that advised me of the new offense. Sorry, I'm distracted.
Okay, and how long would it take you to access that information when you say your emails?
I can look right now. If you just give me one moment.
Okay.
Do you need me to share my screen or it's an email that I had received?
If you could just tell me who it was from.
Let me see. Miss Rebecca Reyes, I received an email requesting the contested MTR, and then they're requesting a supplemental MTR. And this was from the Assistant District Attorney, Joe Ray Garcia.
Okay, so it was the court CLO that notified you of a resisting arrest, correct?
Yes.
And on what date was that email?
January 22nd, 2021.
Okay. Now, one more question going back to the facts of the allegations made in the MTR. You said earlier you don't know exact facts. Do you ever make contact with the complainant in a case regarding facts?
No, I have not spoke with the victim.
And so you also agree that you would not know any facts as far as the victim's point of view on the matter regarding the cases or allegations, correct?
Correct.
Okay. And then just a couple of final questions regarding your overall monitoring of Mr. Scott's case. So you were not the probation officer the entire time he's been on probation, correct?
Correct.
Okay. And at the point in which you took over his case, was he more than halfway done with all of the conditions?
I believe so. I believe he was more than halfway done with his conditions when I received this case.
Okay. And so overall, do you agree or disagree that he's been in your experience a good probation? I wouldn't say candidate because he's already on probation, but a good probationer.
What I say in my overall opinion?
Correct.
I mean, as far as his conditions and his what he is supposed to do for his conditions, mostly yes. Despite the issues with the victim on file.
Okay. When you say the issues with the victim, what are the issues with the victim that are on file?
The several MTRs or VRs that were done.
Again, and these are just
All
allegations.
right, everyone,
correct?
I'm sorry, just one moment, please.
It's burning.
Norma?
Yes, ma'am.
All right, can you send a link to Cornelius Cox, please?
Yes, ma'am.
All right, and I'm sorry for the interruption, Ms. Perez, you may continue.
Thank you, Judge. So, Officer Cirilo, so going back to what the comment you just made about issues with the victim.
Mhm.
You agree with me that all you know are allegations, correct?
Yes.
You agree with me, as you testified earlier, that all you know is the title of an offense, correct?
Yes.
You agree with me that you have no knowledge of the facts surrounding any of these so-called date that these issues arose, correct?
Yes.
You agree with me the fact that you've never communicated with the victim or the alleged victim complainant, and whether or not she can agree or concede to the allegations, correct?
Yes.
Okay. And so overall, you agree with me that really you don't know much other than the title of an offense, correct? Or what's standard procedure for officers to put in or auto-populate in a form?
Yes.
Okay. So do you really sit here and testify to the court today that you feel comfortable recommending he's revoked and potentially has a conviction placed on his record based upon what you know? Or are you just doing it because maybe that's what a supervisor has pressed you to do, or maybe that's just what standard procedure is for your office?
Based on the several MTRs, the SBR MTRs, that our recommendation is revocation.
That you agree with me, you know nothing about?
That is my recommendation, yes.
No further questions, Judge.
All right, State, any questions?
Brief redirect, Your Honor.
Yes, you may proceed.
Thank you. Ms. Cirilo, when you file a violation report based off condition number 1s, it's not your job to look at a police report and determine what offenses were committed. Is that right?
Correct.
Is it in your job description to know the penal code and supplement a report if you find new offenses?
No.
Would that be a job of a lawyer?
Yes.
Specifically, would that be a job of an assistant DA?
Yes.
And let me kind of clear the air of talking about no harmful contact and no contact at all. In this case, did it go back and forth with a no contact order?
Objection, Judge. The state is objection narrative, I'm sorry.
That'll be overruled. You can answer the question.
And let me repeat it for you, Ms. Cirilo. So with this defendant, while you were his probation officer, did it go back and forth from a no harmful or injurious contact to a no contact order at all? Did it go back and forth in different times during the duration of his probation?
Yes.
Okay, and let me ask you, would it be a violation of probation under the no harmful or injurious contact to threaten a victim?
Yes.
Would it be a violation to assault that victim?
Yes.
Would it be a violation to verbally abuse that victim?
Yes.
Thank you. No further questions, Your Honor.
All right, defense, any other questions?
Yes, just one follow-up, Your Honor.
Yes.
Officer Cirilo, you
Yes.
answered yes to Mr. Garcia's last 3 questions, correct?
Yes.
But you also answered yes that you had no knowledge that those things occurred or the facts that surrounded those allegations of my client, correct?
Yes.
Thank you, Judge. No further questions.
All right, any other follow-up?
No, Your Honor. May this witness
This
be
witness excused or subject to recall?
for the state, we're asking her to be excused. That should be fine.
Defense? Is she
She can be
excused? Or-
excused. Excuse,
All right.
Your Honor.
Ms. Cirilo, you're excused. Thank you for appearing.
Yes, ma'am. Thank you.
State, call your next witness.
The state calls Detective Edwards. Your Honor, may I go in the breakout room to retrieve him?
Yes. Any objections, Ms. Pettis, to him retrieving the witness from breakout room number 1?
No objections, Judge.
Yes. State, you may go.
And we're back whenever the court's ready, Your Honor.
All right. I'm sorry, I'm just trying to find you on the screen. All right, Detective Edwards, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. If you could state your name for the record, please.
Detective Charles Edwards.
All right, and I'm going to ask you to keep your voice up because the court reporter is trying to take this down. So if you can speak at the level that I'm speaking, she'll be able to hear everything.
Detective Charles Edwards.
All right, Brennan, is that good for you?
Better.
Thank you. State.
Detective Edwards, can you please tell the court what you do for a living?
I am a San Antonio police officer. I have been on for 18 years. The past 5 years, I have been a detective, handling evidence, almost like a CSI, a UBDI, they call it, uniform evidence.
Okay, and what are some of your current duties?
Well, I kind of just changed jobs, but at the time of the incident, I was handling calls. Somebody would call me if they needed processing for evidence. That was my main job, but if they needed me for a call or any other reason and I was available, they would send me.
Okay, and you said the time of the incident, was that on November 23rd, 2020?
Yes.
And were you on duty that day?
Yes.
And on that date in question, the incident you were involved in, did that involve a man named Cameron Scott?
Yes.
And is he on your Zoom screen today?
Yes.
Can you please identify him by an article of clothing?
He's wearing a little necklace, looks like a black shirt and a mask on.
For the record, the witness has identified the defendant. Now, Detective Edwards, let's go step by step. What happened on the date in question, November 23rd, 2020? When were you first involved with this case? How did you come to know about its whereabouts and what was going on?
The dispatcher assigned me a call for a burglary in progress. I was one of the closest officers to the incident location. And so I was dispatched over there. They had, I guess there was really nobody else available. So they sent me, like I said earlier, that's one of my duties.
Okay, and you're dispatched over there. Where was that?
It was off of Woodstone at an apartment complex.
Okay. Was that in Bexar County, San Antonio?
Yes, yes, Bexar County, San Antonio.
Okay, and when you were first dispatched there, what did you do? What happened?
We arrived at the location to the apartment that was given. We knocked on the door. We tried to listen to see if we heard anything. We didn't hear anything. The call was for a burglary in progress, so we were kind of looking as if there was any forced entry, broken door, anything like that. We didn't hear anything. So we got back with the dispatcher to call and make sure that that was the right location given. They talked about somebody else had called from another side of town. So they were trying to figure that out. But they did get back with the supervisor and they listened to the 911 tapes. And that was the location given. So we did return back to that location. I wanted to go to the neighbor to see if they had heard anything. And while we were knocking on the neighbor's door, going up to the door, that is when I heard a female screaming from the apartment that we were originally dispatched to.
Okay, so the second time you were walking back through the apartments, were you with another officer at that time?
Yes. Officer, I want to say Diaz, Officer Diaz. Yes.
Okay, and as you stated, you approached that door, you heard a female's voice screaming. What did you do?
She was screaming for help. It wasn't very loud, but it was enough to know that she was in some sort of distress. And with the burglary call, we proceeded to make entry. We tried to open the door. It was locked. I told Officer Diaz to try and kick open the door. I think he tried 2 times to kick open the door. It wouldn't open. I told him to break the window and to unlock the door. Then we made entry inside the location.
Okay, and at this time, were you wearing a body cam?
Yes, I was wearing a body cam. I was in full uniform.
Okay. Your Honor, permission to share screen?
Brandon, is there any objection to the documents or video that I believe the state is seeking to enter into evidence?
Well, Judge, I don't know what he's trying to admit or offering.
What are you going to be seeking to admit the body cam from this officer?
Yes, Your Honor.
Okay, that's what your body cam, then no objections, Judge.
All right, Mr. Garcia, what exhibit number is that?
Your Honor, this should be exhibit number 3A and 3B. There had to be in 2 clips, the reason for an A and B on each video.
All right, defense, any objections to state's exhibits 3 and 3B?
Judge, I would just ask that the state provide me with the exact time of where on the entire body cam he's looking to admit, I guess, because it's, I don't know if it's the whole thing or if it's portions.
Okay.
I'm admitting the whole thing that he has. For the interest of time, I'm going to play the pertinent parts of the video that deal with this issue.
All right, so he's seeking to admit the entire body cam video of this officer, and my understanding that's exhibits 3 and 3B.
Correct, Judge. And so I will object to the fact that not all of it may be relevant. Furthermore, the fact that some of it may be more prejudicial to my client and may require a motion with the court, considering the fact that some of those statements may have been made while he was not in custody and so forth.
Wait, have you all reviewed this exhibit?
I have.
Yes, Judge, but there's a good number of police body cam, number 1, and number 2, there's different portions of inside, outside. So that's why I'm asking if the state can provide me with an exact time. That way I know.
All right, I'll send you all to a breakout room. We can go off the record, Brenna, but this is what everybody needs to understand. The jury in this case is the court. That's me. So any objections you all have to maybe something he said and you think he should have been in custody or he was in custody and you're objecting, I'm going to be the person to hear that. So if you all want to go to a breakout room, review the video, you can. If not, I will hear whatever you all want me to hear and make my rulings.
In an effort to make sure that we're good on time, Judge, if Mr. Garcia can just tell me the time, which I'm sure he has it right in front of him.
All right, this is what I do. Mr. Garcia, if you go to breakout room number 1, Ms. Perez, if you go to breakout room number 1, and I'll meet everyone there.
Okay.
And Mr. Martin, did you want to come to number 1 as well? All right, Paula, did you get the?
There it goes. Okay.
All right, thank you.
The 288. He's just right here. In the 288. He's the only civil case, civil court on this side of the building. I thought he gave you his number.
No, but I just put in my contact.
Huh?
Put his name in my contact.
Oh, the 288. 288 civil.
Norma,
Yes, ma'am.
can you see if there's an attorney available to represent the complaining witness in this case?
Yes, ma'am. Give me 1 second.
See if they can zoom in.
Judge, I found someone. I'm getting them to log in.
All right, thank you. And does anyone know who is K51? Yes, you're muted. Could you unmute?
Yes. Your Honor,
Yes.
I think that's my aunt. She's gonna be a witness.
Okay. All right. I'm going to admit her. We'll find out. Okay.
Okay, thank you.
You're welcome. Hello, K51. What's your name, please? You need to unmute.
Okay.
All right. What's your name?
My name is Carol Scott.
All right. Just give us a moment. Okay.
Uh-huh.
All right. Paula and Joe Ray, have you all had a chance to review everything?
Yes, Judge, we can go ahead and proceed. I'll have no objections at this time to what the state is looking to admit as far as Officer Edwards' body cam.
All right. So here's my question. Joe Ray, Brenda told me that you uploaded it into the share drive.
Yes, Judge.
You put it in a folder?
Yes, we created a folder and then I labeled the exhibits like I show them on the screen and entered them.
All right. And did it go to the 187th share drive? Because I don't see it in our share drive.
Let me go on the website again. I checked the other day. I saw it. What is it called, or what's the name of it again?
It's Bexar County Court 187, Judge Stephanie Boyd.
But where I share the files at.
Yes, if you go to
So there should be a Cameron Scott file.
Yes.
And then you'll see like admitted exhibits where judge allowed you and I access, I think, or maybe
Yes.
just me.
All right, let me do this. I'm going to open a new folder for you. Just give me 1 second. You know, it's just popped up. All right, just give me 1 second. Charles Bonk?
Back.
You're muted, Mr. Bonk.
Here I am.
Mr. Scott, just give us a moment. Mr. Bonk, I'm going to send you to breakout room number 5.
Okay.
And Ms. Pettis and Joe Ray, if you could go to number 5 with Mr. Bonk, and they'll explain to you what's going on.
Okay.
And I'm going to move Ms. Villarreal to number 6. So once you all have told Mr. Bonk what's going on, then I'll move you to 6. But for now, go to 5, Mr. Bonk.
Yes, Judge.
right, and Brenna, can I see you in breakout room number 1, please?
Yes, ma'am.
And Norma, could I see you in 1, please?
Yes, ma'am.
All right, we are back. And Charles Blanc, I'll send you to a breakout room with Miss Villarreal, and she's
Okay.
in breakout room number 6.
Yes, Judge.
All right, and we're State and Defense, are you all ready to proceed?
Yes, Your Honor, status.
All right, State.
Your Honor, at this time, the state moves to enter State's Exhibit 3A and State's Exhibit 3B.
Any objections?
Objections, Judge.
All right.
Permission to share screen, Your Honor.
Permission granted.
For the record, I'm starting the video.
And which video is this?
I'm starting video on State's Exhibit 3B. And Your Honor, I'm going just for the court's information. I'm not putting it in full screen because I noticed on trial runs it becomes more pixelated and behind. The sound quality and the picture still is distorted because of the shared screen, but there's nothing I can do
Okay.
to fix that. Starting video.
And State, is there sound at this point or no?
There is, Your Honor. Are y'all getting any sound?
No, we're not hearing any sound.
Oh,
There's probably no sound at that point to hear.
yeah, it came on. There's
Yeah.
sound now.
Okay. All right, let's proceed.
Okay. And could y'all hear the knocking?
Yes.
Okay. And I'm stopping the video at 1 minute, 32 seconds. Officer Edwards, I know on your end, the sound may be distorted, but at this moment, are you hearing anything from inside the apartment?
I don't think so. Not right at this second. No. You can see me go up to the door and I'm trying to listen to see if anything's going on. And now I'm knocking on the door, but I think in a moment you'll be able to hear something.
Okay.
There.
And your officer, what's happening right now? Can you hear anything on the video?
Yes, I heard. That's what I said right there. You can hear real distinct, like a scream, like 2 screams. And that's when I told him we got to get in there, kick open the door. She may be in trouble.
And on your end, can you hear, or do you remember a woman screaming, "Come in, come in"?
I don't remember come in. I remember help.
Okay. Proceeding with the video. And officer, I believe you briefly stated it before, but why did y'all decide to break the window of the apartment?
Because we didn't know what was going on inside. All I have is a call for burglary in progress, and then I have a female screaming inside. So exigent circumstances, I need to get in there. I don't know, if the worst of the worst, she could be being stabbed to death, or, just having an argument and needs our help in there. I mean, there's so many possibilities. But if I have someone screaming inside a house for help, especially while I'm there on a call for a potential felony, I need to get in there and make sure she's okay or he's okay. But in this instance, it's a female.
Proceeding video at 2 minutes, 11 seconds.
All right, just one moment. Defense, you have a witness here. It's the defendant's aunt. Her name is Cirilo Scott. She's been placed in breakout room number 1.
Okay, thank you, Judge.
You're welcome. State, you may continue.
Proceeding video at 2 minutes, 11 seconds. Pausing the video at 2 minutes, 54 seconds. And Detective Edwards, when you entered, did you ask or command the defendant to do anything?
Yes, I saw the defendant over in the corner towards the little kitchen area. I could hear kind of arguing going on. I told him to get down on the ground. That's when he came towards me. He said, "You're gonna have to shoot me." At that instance, that's when I put my gun back in its holster. And then that's when we went hands on, and I'm trying to just detain him at this point.
And because the sound may be distorted on your end, do you remember if the female in the room is shouting anything for him to do, or if she's stating anything at all?
I don't remember. I just remember they were kind of arguing back and forth. I don't remember exactly what she said. Yeah, I don't remember on that point.
Would it surprise you if she stated that for him
Judge, objection, leading.
Sustained.
Judge, I also can't hear the sound on this, so I don't even know if what officer is testifying to indeed is what is occurring on the screen. I'm not sure if everybody.
Stop the video, please. The court is in receipt in the shared drive, the exhibits that both the state and the defense have admitted into evidence. If both parties want, what the court can do is can use it through the shared drive, and maybe the sound will not be distorted.
Yes, Judge, I would prefer that.
I was going to request that, Judge, if you wanted to review it. There still may be a problem though, because I know from previous before when you shared things that the audio is not there either, but we try it.
All right, if you will stop sharing your screen, please.
It's on 3B, Your Honor.
Oh, it's 3B? Just give me one moment. Is this
Was that on 3B? Then that's
just
it.
one moment, let me see. You're saying it's 3B?
Yes, Judge.
All right. All right, here we are. Is everyone able to hear? Is everyone able to hear?
I don't hear anything yet, Judge, and it's paused right now, right?
All right, no, that's what
Okay.
stopped it.
Just want to make sure.
And Judge, just for me, it's I can't hear.
Yeah, same here, Judge, but I'm assuming if the court can, then that's okay.
Yes, the court is able to hear.
Okay.
All right, everyone, just one moment. Because I'm being told that nobody can hear. We're going to try to see if we can work out the audio for everyone. Because on my end, I'm able to hear everything and it's very clear. So I'm going to see if I can have a microphone brought back into my office. Just give me a moment.
Joe Ray,
Yes.
when you share, is there an option to say share sound?
And I'm
It says,
looking on that, Brenna, and it's not on there.
yeah, bottom left corner, share selection window.
Judge, Lance should be coming in. I don't know if he's in the waiting area.
All right, he's here.
Okay.
Thank you, Lance, for coming in.
Judge, if it's okay, can I step away to use the restroom real quick?
Yes, you can. All right, we'll see what happens in case this doesn't work. All right, everyone, just give me a moment. And Brenna, can you come in breakout room number 1, please? Paula, we are back and we have, well, I will say we figured it out, but actually Lance made it happen.
Okay,
So
great.
to the courtroom, could I have you show your video, please? Thank you. All right, we're going to share screen and we'll start back over from the beginning. Is everyone ready?
Your Honor, Ms. Bettis's client went to the restroom.
Okay, all right, we'll wait for him.
Judge, I know the defense invoked the rule. I believe there are witnesses in the main room.
No, she is actually in a waiting room.
Oh, okay. I see your name on our
Yes.
screen.
No, she's in the waiting room. Which witness are you speaking of?
Complainant.
Yes.
Let me see. Miss Felicia Villarreal, you need to go back to breakout room number 6.
That might be my fault, Judge. I told her to come back to the main room once she and I finished.
No problem. And Mr. Bach, you can see some I'm sorry, did you have a chance to speak with the state and the defense?
Yes, we spoke.
Okay.
And then I spoke with my client, so we're ready.
And
I'm
are you-
ready for her. Until then, I'll just sit back and watch some good lawyering.
All right, thank you. Okay, we are back. And I am going to share the screen. Just one moment. All right, is everyone able to see the video?
Yes, Judge.
All right, then we will start it. And is everyone able to hear now? Is everyone able to hear now?
No, Judge, I can't hear.
I don't hear anything. No.
Just one moment.
I don't think there's anything to hear at that point.
No, there is noise because I made sure there was noise. Just give me a moment.
Yeah, it pops on right there.
Just 1 second. All right, let me know if you're able to hear.
Yes.
Yes.
I can
Okay.
hear a lot better. Yes.
Thank you.
Go for it. 340. We're trying to make entry into the apartment. 335. We're making entry. Trying to kick open the door. Break the window? You need to, yeah. I'm there. San Antonio Police! Get down on the ground. I'm not getting on the ground. Get down on the ground.
May I proceed, Judge?
Yes.
Detective Edwards, I know we're in the middle of discussing it earlier. During this scuffle, what exactly happened? Was the defendant tased?
Yes. We were trying to get him to comply about putting his hands behind his back so that we can handcuff him. He kept just passively resisting. He kept trying to get back to the victim and to the kitchen the whole time. We were afraid that he was gonna assault her or do something, I don't know.
And you say to the victim, was that the female in the video?
Yes. With
And
her,
this whole time, was she holding an infant?
yes, she was holding an infant.
Were you the one that tased the defendant, or was it the officer that was with you?
It was Officer Diaz. He told me that he was gonna tase the defendant for just resisting, not listening to our commands. I told him that he was too close and to dry stun him. So he proceeded to dry stun him.
And what exactly does compare to dry stun compared to, just saying tasing? What's the difference?
So there's a cartridge that shoots out the electrodes, and they teach us, if you're too close to the person, that those aren't gonna be as effective as a just straight up dry stun. So you remove the cartridge with the probes, and there's already an electric charge on it.
Okay, and once you dry stunned him, did the defendant go to the ground?
Yes, he went straight to the ground. And we then continued to try and handcuff him. And he basically lifted. I was the one on his back, trying to get his left hand behind his back to handcuff him. And then that's when the video cut out. Either I told the officer to dry stun him again because the defendant lifted me off the ground. So I don't know if it was either the stun, because I got a little bit of a charge also that cut off the camera, or if his back hit the camera. And that's when it cut out right there.
Okay, so I was going to lead into that is, you may not be exactly sure, but your theories on why your body cam cut off. Can you repeat those, please?
Yes, I'm pretty sure that when I was on his back and he was lifting me.
Objection, speculation, Your Honor. In addition to that, the evidence speaks for itself. We have a video, his body cam in front of us, as well as other officers' body cam. I don't understand why he's narrating this situation. That's why we have the body cam.
I will sustain your objection as it relates to speculation.
Okay. Let me rephrase. Detective Edwards, during this entire scuffle and the defendant being tased and his unwillingness to get on the ground, is that when your camera turned off?
Yes.
What happened after that?
Another detective came in. Well, I told Diaz to dry stun him again, and then that's when the camera cut off. We continued to try and handcuff him. Another detective showed up. So we had 3 officers, and we were able to get him in handcuffs. And as soon as I got to my feet, I realized the camera was off, and I turned it right back on.
Okay. And once the other detective got there, was the defendant arrested?
Yes.
And what was your involvement with that?
At that point, once we got him handcuffed and everything, I didn't talk to the victim. I didn't talk to anybody else. I helped get him out to the car, and that was pretty much it for me.
So your involvement with this case, as you said, pretty much ends there?
Yes.
And I know this may seem like a simple question, but as your experience as an officer and as a detective, is it your opinion that the defendant was a resisting arrest at this time?
Yes.
Pass the witness, Your Honor.
All right, defense.
Officer Edwards, so did you have a report from that evening?
Yes, I did a supplement report.
You did. And do you have that report in front of you?
No, I do not.
Okay. Is there any reason why that report would, well, let me backtrack. Would that report, you would have sent it over to the DA's office, correct? Or does Officer Flores do that?
I complete it, and then what they do with it, that's on theirs. That's the DA's part and the ADA, I guess.
Okay, so to your knowledge, does the DA have a copy of your report?
I'm not sure. I mean, I don't know.
Okay. Judge, just before we proceed, I need to confirm with the state if there is a report, because to my knowledge, there is no report. So I just want to make sure that before we continue.
State, is there a supplemental report?
Judge, all I have printed out is the main report. I am looking on Veripic.
There is not, as of e-discovery earlier today, I made sure, just to make sure there's nothing else uploaded last minute, there was nothing there.
All right, we will find out if there is a supplemental report. And Norma, what is our docket for tomorrow?
It's like 4 pages, Judge.
All right, for some reason, the docket you sent me, I don't have the 4 pages. I only have 2.
Let me see, Judge.
Do we have anything set in the afternoon?
No, ma'am.
All right. This is what we're going to do. We're going to take a break at this point. If there are any, Detective Edwards, if you have any supplemental reports, state if you have any supplemental report by this officer or any other officer, the defense needs those reports.
It's loading. I'm trying to figure it out as well.
And we will be back here to complete this tomorrow at 1:30.
Paula,
yes.
Now I think. So I'm gonna double check. What I think happened is it was a very, very short part, and it's included just on the upload for the one PDF that's on there. That's my assumption, but I'm going through it now.
Okay, yeah, there is only one PDF there, so, and then that's why I had made sure to ask you again.
I think it's more stuff on that PDF. Do you get what I mean? I think it's like really short what he would have written, but
Okay, so this is what I'm going to do. I'm going to close the breakout rooms. Everybody's going to come back into the main room. We're going to pick this hearing up at 1:30 tomorrow. I want the defense and state to remain to make sure that the defense has all of the police reports. And the officers are going to be coming back in the main room. So state and defense, if you all can find out if there are any supplemental reports, you're more than welcome to do that. So you will have all you need to continue this hearing tomorrow at 1:30.
Yes, Judge.
Yes, Judge.
And the breakout rooms should be closing now. And we're going to stop live stream, and this hearing is going to be continued tomorrow at 1:30. But of course, the 187th will be open.